It's delightful to be here and to share the podium with such amazing people, and thank you all for making the trip out to sunny Campbelltown. A few weeks ago we had the New South Wales election, and putting my heart on my sleeve, I am, not on this issue but for other reasons, a supporter of the Greens, and in fact was handing out pamphlets for the Greens. And there was a lady, well, you'll find out in a minute, because there was a lady standing next to me handing out, I'd never heard of this party, the Voluntary Euthanasia Party, so a lot of you here would be aware of it. And what caught me here was that dying with dignity should be a basic human right, at the very top. And that, I thought, that's great, the Lord works in mysterious ways, because the day before, Catherine had asked me to come and talk to you about this issue, of which I don't, thankfully, have personal experience, but she asked me to come and talk from a human rights perspective. The whole issue raises moral, ethical, philosophical, religious, constitutional, legal, a whole bunch of considerations. Just so we know what we're talking about, although you'll see these definitions are not particularly clear, what are human rights? Well, that's a really, really difficult question. So I've gone to some fundamental source areas. The fundamental source document, if you like, is this wonderful document here, the Universal Declaration of Human Rights, the most translated document in the world, even more than the Bible. And the Universal Declaration says that we have human rights in, quote, recognition of the, and they're the words, inherent dignity and the inalienable rights of the family. And the Office of the High Commissioner for Human Rights, again talking about rights inherent to being a human being. So that's what we're talking about. Some difficult issues about human rights, and again, this is not a lecture on human rights generally, but I'd like to put this into perspective, is that typically human rights and the enunciation of them give rise to rights for, let's say, individuals, but also corresponding obligations on the state. We all like to talk about universality of rights, i.e. they apply to all human beings, irrespective of race, colour, creed, gender, sexual preference, whatever. And irrespective, depending on your definition of what a human being is, of their awareness, their competence, their autonomy. Now, the universality gets challenged in different ways, cultural relativism and all of that. We talk about different types of rights. So for reasons that are beyond this discussion, we have different source documents talking about different types of rights: civil and political rights, social, economic and cultural rights, collective rights. So rights is a complicated thing. We talk about moral and legal rights, and what are these things that are enunciated in here? Are they coexistent or dependent? Is morality the yardstick by which we then determine what is legal in this sphere? Lots of competing interests in human rights between typically the individual and the state, and also, as we've heard, the broader community. And of course, there are all sorts of issues of enforceability. Okay, you're now all human rights law experts. So, I'm going to concentrate on one fundamental human right known as the right to life, because that seems to be the most appropriate and relevant right to add into this complex matrix of debate, although I will, on one slide, just mention a couple of other rights, but I'm really focusing on that. In here, this is the yardstick, the beginning. Everybody has the right to life, liberty, and security of person. Subsequent to the Universal Declaration, we've had a whole bunch of treaties on a regional basis, by and large. Now, lots of words, don't worry. The point here is, you see my question mark. Do we have a universal idea of what this means? If you just take the first two, which is the document that I'll concentrate on for the rest of the talk, the International Covenant of Civil and Political Rights, of which Australia is, of course, a party. Every human being has the inherent right to life. These shall be protected by law. No one shall be arbitrarily deprived of his life. I'll go through that in a bit more detail in a minute. But just compare that, for example, to the next one, European Convention of Human Rights, 1950. First really major human rights document. And look there, the second sentence. So the first sentence talks about protection in law, in terms of your right. No one shall be deprived of his life intentionally. There's nothing there about arbitrariness. It's a different right. It's a different right. And without boring you with all the details, these different regional notions of a right to life differ. And because we're lawyers and, for us words are important, the different words can be interpreted in different ways. And in an area as difficult and complex as the one is that we're talking about, the difference in words may matter. Okay, some other rights, I'm not going to concentrate on these, but just for the sake of completeness, in various cases that have been brought up dealing with various issues of assisted suicide, of euthanasia, of the right to death, etc. People at various times have brought up this article, which is the prohibition on inhumane and cruel treatment, then the rights to privacy, freedom of thought and conscience, even discrimination, because there are issues about discrimination against particular sexes or whatever. Okay, they may or may not be relevant. They're probably less relevant than the right to life, and we don't have time to go through them anyway. So let's just focus on the right to life. Okay, so we're going to look at what does it all mean? What does it all mean in the context of this issue? So all human rights and their corresponding obligations, they've got a lot more depth and nuance and complexity than is evident from just reading the words. The manner in which the right is applied, the limitations that are applied to the right, the type of balancing that will go on given these different agendas and competing interests. These add to the difficulty and raise really complex questions about what a right means and how it applies. There's a whole range of factors. So, I'm repeating here the article from the International Covenant on Civil and Political Rights, the right to life, and I've highlighted a couple of words. This right to life is described by many as the fundamental, the primordial, the supreme right, from which everything else flows. We have this word, lawyers have terrible words, that no derogation is permitted. So under the human rights treaties, where there's a public emergency, for example, the state is allowed, in various circumstances, to say, well, for this time being, this right doesn't apply. This isn't one that they can't do that for. But even the right to life is not absolute. Even, in fact, the next paragraphs in this article talk about the death penalty and how the death penalty is still possible and legal, although obviously there are a whole range of preconditions. So clearly the right to life is not absolute, and sadly, as you know, we're going through the death penalty debate at the moment. Okay, there are some interesting words here. It's an inherent right. What does that mean? It means it was always there, perhaps. It certainly means that human rights committees have looked at this right and said we can't interpret it narrowly. We have to look at it in a proactive way. And it does mean that states have obligations. So, some have said, it's not just about arbitrary killing, but it's about protection by the state, say, in terms of things like malnutrition or epidemics or even armed conflict or something like that. The right has to be protected by law. So, states parties to these treaties have to go away and pass the law in their national system that then protects. So, what does that mean? Can a state go away and pass a law that has a completely different interpretation of what they think this right is? And can they say, well, they're fulfilling their duty? They are protecting that right at law. What does this legal protection mean? It's not a guarantee by the state. It's a protection in the formal sense, i.e. through law. I'll come back to an example in a minute. And of course we have this issue of arbitrariness. What does that mean? What does arbitrary death mean? If we had a law, for example, that said the killing of all blue-eyed babies, which is a famous example, is legal, and that law under the Constitution of Australia was perfectly valid, so there's no constitutional issue. There clearly would be, but let's assume there's not. How does that fit in? Clearly that sounds arbitrary. So clearly nothing is clear, but one would say that is a violation of this right. But you don't have laws that say let's kill blue-eyed babies unless you're in Nazi Germany. And so there are many situations where there are laws that are perhaps more circumspect, more proportionate, and it's very difficult then to work out what is arbitrary and what is not. Okay. The definition of life becomes difficult as well. As I'm not a medical person, but you've heard our medical technology, just like all sorts of other technology, is racing forward, and we have ways of preserving life. What is the definition of life? Of course, that's a really heated topic when it comes to the beginning of life in the whole abortion debate. Here we are talking about the end of life. What is the end of life? I was talking at a dinner party last night to a doctor on this very issue. When is someone dead? And she said, well, there are brain deaths and things like that. But there are, I didn't quite understand it all, but she said there are degrees of brain damage. And it's sometimes very difficult to work out death. So if it's difficult to work out what life is, it's difficult to work out when the end of life occurs. What does the inherent dignity, remember these rights stem from the inherent dignity of the human being. So those, for example, who philosophically oppose any semblance of euthanasia and the other types of assisted death, say, well, the right to life, based on this inherent dignity of the human being, is that life itself, it has this sanctity. And so, even from a religious viewpoint or whatever, the sanctity of life doctrine means you can never allow, if it's within your control not to, you can never allow life to end. What does the right mean? Is it a right not to be killed? Does it extend further to a right to have your life saved? Is it both? Is it discretionary or mandatory? Okay, what do we mean by that? Can I waive my right? If I have a right, logic dictates that it's mine to control. I have a right to life. Am I capable at law or under this right to waive it? Given that, as I said before, many people say this is the holy grail of rights. So is it consistent with that sanctity of this holy grail to say, okay, we all have this incredible right, but we are capable of waiving it? If it's discretionary, we can waive it. If it's what we call inalienable, one of the words that was in the Universal Declaration, then you can't waive it, even if you want to. And if you can waive it, does that then give you power to release others from their duty? Whose perspective do we look at? The debates often look at, and we've heard a lot about it, and it's really important, the consent, as Damien said, looking at the consent of, if you like, the patient. But, there are, where you're looking in the assisted suicide or voluntary euthanasia areas, there are other perspectives. What is the corresponding obligation of the state? And how far does that go? Are they under an obligation to look in the best interests of people? There's this amazing play, stage play. I used to be an actor in London, and when I was there in the late 70s, early 80s, there was this amazing play called Whose Life Is It Anyway? Some of you have seen it, it's become a movie, and all of that. It's become a bit Hollywood-like. In that movie, a person who was a quadriplegic, who'd been a sculptor, he just wanted to go home and die, and eventually goes to court. And the judge said, there are precedents for both sides. Mr. Harrison's mind has been affected. However, I'm satisfied that Mr. Harrison is a brave and thoughtful man who is in complete possession of his mental faculties, and I therefore order that he be set free. And that's the end of the play. Okay, letting people die, one issue. Assisted suicide and euthanasia, from a conceptual viewpoint of trying to deconstruct, are different issues. Suicide, of course, means killing yourself. Euthanasia involves another person. There are different types from a legal perspective of euthanasia, ranging from the voluntary to the involuntary, where they do it even against your consent. And then, of course, the non-voluntary in the middle. The Dutch have legislation that allows for euthanasia, and that's been reviewed by the Human Rights Committee, who said, and their job, Human Rights Committee, is under this Human Rights Treaty. Their job is to determine whether countries are complying with their obligations. And the Human Rights Committee said, well, looking at this legislation, it allows, it appears, for truly voluntary choice. And it ensures that any assistance by medical or other people is without any ulterior motive. So the committee determined that that probably was not a violation of the right to life. But is there a right to die? Does the right to life automatically, or somehow can it be constructed to include a right to die? And indeed, as we've heard from some of our speakers, is that really necessary anyway to promote this? Remember, my mandate is to look at it from a human rights perspective. I'm not saying there needs to be a right to die, but lots of people say they have a right to die, and a right to die with dignity and whatever. And courts have looked at this. The European Court of Human Rights has looked at this. Lots and lots of cases, and I won't bore you with the details. But essentially, in Petty's case, the court said, yes, there is a right to life, but it doesn't say you have a right to die, because in that case, Mrs. Petty claimed that the right to life included the right to die to avoid inevitable suffering and indignity. At the international level, we have this right to life, but it is fraught with difficulty, fundamental as it is. The way law works is Australia as a party, and most countries as parties to these international treaties, for that then to be implemented into national law requires national legislation. It doesn't automatically become part of Australian law when we ratify a treaty. And so it gets back to my point, how will the state, a state, implement this right to life in its relevance to the topic that we're looking at today, and many other things? Criminalisation, for example, of euthanasia doesn't necessarily mean a violation of the right to life, for example. So, last point is really the point that I started off with. There are lots and lots and lots of issues at stake here. Many considerations of a non-legal nature. And in a sense, a point forcefully made by Damien particularly, in a sense, it's those other non-legal factors that really we need to look at, and to the extent we need legal solutions or tools in this area, they have to be driven by public policy, morality, culture and others? Is someone who assists to be regarded as a hero or a villain, or both? So the final point is this issue involves many factors. One of those factors we need to look at is from a human rights perspective, but it's not the panacea, it's not the answer, and it's certainly not the single determinative factor. Thank you very much.
Kristen was actually the one that I found most relevant. And my aunt a few years ago was in intensive care because her bowel had ruptured due to bowel cancer, which we didn't know about until after she died. I was sort of asking the medical team if they could delay the surgery that they were proposing until my uncle and sister came from interstate, because they were very close to her, and she was probably going to die. Everybody acknowledged that. Now, they weren't going to ask my aunt for consent for the surgery, except that I insisted. She had no trouble talking. Her voice was very soft, but she had a full oxygen mask on her face, so that had to be taken off for her to be able to give consent. Now, when the surgeon spoke to me, he said that best case scenario, she'd be in a nursing home for the rest of her life with a colostomy bag, but there was a very, very high chance that she would die either way, with or without the surgery. He also said that if she'd had a living will, I take that's the same as Advanced Care Directive, it would be different, but under the circumstances, he had to do surgery as soon as possible. Now, I did convince them to ask for her consent, and at first she said no, but she was not presented with the same information as me. She was just told, you've got to basically do this, or you're gonna die. Like, it wasn't, and she'd never said no to doctors in her whole life. She used to joke that her mother always taught her never to say no to anything except for one thing, which is she never had children, and we were the closest to her. So the surgery went ahead straight away. She died on the operating table. Resuscitation failed, but she was put on life support machinery. She was gone, basically, is my belief. She was kept alive, according to them, alive on this machine for several days in intensive care, because I feel that was because they were concerned about our feelings as the family, and they like to ease you into this thing, of turning off the machines. And, for me, I feel that, and it sounds horrible, but to me, I feel like the surgeon wanted to do the surgery because that's his job. Mm. Now, I know that he would not be conscious of that motivation, right? I'm sure he would not be, and but that was my feeling, and I know what a good death looks like the third speaker, because I helped my mother care for her partner dying with cancer at home with help of the palliative care team, and I just feel that Kristen actually makes the most pertinent points to me, and that we need to change this culture around this fear of death and have more discussion, because it's a really important issue.
Thank you. Kristen, would you like to respond to that?
I think that must have been very difficult for you and your family. I don't like to sort of draw too many comments on individual cases because I wasn't there, but it's clearly very complicated. And I think there's lots of complicated issues. Did the doctors feel she wasn't going to be well enough oxygenated without the mask to give consent? Which is why they weren't going to do that. Another thought flashed through my mind. And again, I don't want to reference this back to your case, but I think it's a general comment that doctors like to do our job. That's what we're trained for. And so for a doctor to come to a family and say, I'm not going to do what I'm trained for is really quite difficult for all of us. And sometimes when I have patients who I think really need palliative care and they say, "Nope, I'm going for cure, doc, I don't want to see you," I have to suck it up and go away, right? And I personally don't find that easy. So I think there are issues abounding all of this, but as I say, I don't want to really kind of get into the nitty-gritty of commenting on cases because I'm not actually there and I don't have all the information.
Thanks, Kristen.
Can I just make a comment?
Yes, Trevor, please.
Could I just make this observation in terms of the educative process? There's been a number of studies done in the United States that looks at the simple question of the expectation that people have of what will arise out of CPR. And they're educated on this by watching Grey's Anatomy or whatever else. And if you go and look at those programs, about 75% of the people, I think, make a full and miraculous recovery from CPR. Well, obviously there's people in the medical profession or training here, and they all know that that's a load of bunkum. You know, that's subject, of course, to where it occurs. The consequences of somebody requiring CPR are generally pretty grim and become grimmer and grimmer by the moment. Now, if on something such as that, something as simple as that, people have an unrealistic expectation, I think it's a big ask to actually train to an appropriate standard the community generally as to what should be a realistic expectation from surgery or from some form of medical intervention. One of the studies that was done in the United States that was related to that was how do doctors in the United States respond to the bad news, for instance, of cancer. Their prospect of entering into an advanced care directive or, for instance, to refuse treatment is immeasurably higher than the general population. That is, they're appropriately cynical about what the outcome is and that the quality of their life may be from that treatment. They're medical professionals. They get it. The general population on the whole won't. But let me make this point. There are sections of the community that do get it, or they see that the consequences for them are not going to be particularly high. Now, whether you do it by way of a legislated advanced care directive, which is still my preference, or whether you do it by the common law, the answer is people have to actually understand that they can actually enter an advanced care directive, and they need the assistance to be able to enter into an advanced care directive that's more than the short-term do not resuscitate advanced care directive, which is what most people understand. The reason, and I'll raise it in this context, the reason that I'm in favour of some form of legislative outcome is because of this. When I first started to practice medicine, when you had a client come in to do a conveyance, which I tried to avoid, the one thing you gave them or got them to do after they'd done the conveyance is their will, right? Because you had them in the office, and you could get another $100 out of them if you could get them to do their will. And then we introduced this concept of guardianship orders and the like. Enduring guardianships. And once that legislation passed, lawyers suddenly decided, well, we won't only get them to do the will, we'll also get them to do the enduring guardianship. Why? Because there's $200 to be made now, not 100. But partly it was an educated thing, that the lawyers started to understand that there was another component and another discussion to be had. I'm a lawyer, so I like to see my profession grow. But it seems to me that one of the additional components that needs to be done in an educative sense is for somebody to start the conversation on, look, you know, I know you're only 60, you've got another 20 years ahead of you, but have you thought about these consequences in the event that X occurs? That doesn't occur anywhere in the community. And it's very hard to find the person who's actually going to start that conversation with somebody.
But for most people who don't suffer a chronic condition or don't have a particularly strong belief, like a religious belief, advanced care directives aren't that particularly useful. because you pie in the sky, I don't really know, you tend to write things that are involving languages as indeterminate. Like, I don't want heroic measures or something like that. It's not particularly useful. I think what would be useful is use the enduring guardianship form, which allows you to set out your statement of preferences, which then gives the person who's making decisions for you the option to take that into account. And you can put directives in there. They're not necessarily legally binding in the same way the directive is, but it's more useful, I think. So if I'm someone with a chronic condition, so I've got chronic obstruction pulmonary disorder or something, that's when an advanced care directive is going to be really useful, because I know in the next 18 months I'm going to be educated really well about what's going to happen. If I need a bone marrow transplant, I'm going to go through a day and a half of education to let me know what the treatment options are. Then you can go advanced care directives then. If I'm a Jehovah's Witness, they do the best advanced care directives you've ever seen, right? They have whole days where they sit down and they do their advanced care directives together. They can do it well, but most of us aren't in that category yet of chronic conditions or illness or strong religious beliefs. So for the rest of us, I'd stick with the enduring guardianship. I think that's the easiest way to go. But the thing is, you need to have that, because if you don't have that, under the legislation, no one else can then be involved in decisions about your care. I think the doctors do it regardless, as we've seen. They will include you and they will try to, but some of them don't. So you're left with more of the whims. Get the legal certainty. Let's fix the legislation up. It's easy to do.
Can I ask
Elizabeth Atkin from the Carers Program, South Western Sydney Local Health District. I'd like to say that there are training programs happening right now, and particularly through the Carers Program, dealing with people with chronic disabilities, chronic care patients, palliative care patients, people with mental health issues, those types of things. And we're trying to do that way back in the beginning and doing it as a package type of program. So we're not only covering the enduring guardianship, but we also talk about financial managers, advanced care planning, getting back to the basics of looking after yourself. The whole thing being to improve well-being of yourself as a carer, to be able to better care for the person who is unwell. So we're trying to take a very much holistic approach and provide the information and the documents for people to use and provide a discussion point. And this is what I call the dealing with the D words, even getting as far as looking at donations if people are interested in that sort of thing. So D for dots to put under the furniture, D for the documentation to make sure that people know and where to register that documentation. D for death, you know, what do you want to happen should that become a very imminent proposition. So, you know, yes, the education and community awareness is actually happening out there.
Thank you.
Can I just say quickly something? I mean, there's a lot of community work being done on advanced care directives, and that's the thing that the legislation would probably kill. Because once you have a legislative form, that tends to disenfranchise a lot of people. And that's certainly been the experience in Victoria. In Victoria, they've had advanced care directives for decades. But you have to have a current condition for an advanced care directive to work under their legislation. Being a Jehovah's Witness is not a condition. So they can't make advanced directives using the legislation. So why have a piece of legislation that attempts to give you stuff but then takes it away? And that's the danger. Again, in Queensland, very restricted, only 4 circumstances where you can have an advanced care directive work. WA opens up. They do have a form and it's open, but the risk is if we go for legislative advanced care directives, they'll take away your freedom to make them as, and that's the risk. And there's always pressure on limiting them. If we go to Parliament, there's always forces, there's always compromises, and those compromises tend to, at least in the Australian experience, limit the availability of advanced care directives, not make them more available.
I've got a question. Please.
Yes, please.
I don't know all this law stuff. So it's a question for Cameron, and I have to say I did a bit of double take when he told me that what I did with substituted decision-making, person responsible, was not, I'm paraphrasing here because I'm said, not legal was what I heard. Maybe not what you said, but what I heard. Okay? And I had understood this issue about when the Guardianship Act came out, I was practising palliative care, and as you know, it's got all these phrases about, you know, we couldn't give morphine to people or haloperidol. Some of the drugs were used very commonly to people unless if they were incompetent, we had to get permission because it was special treatment from the Guardianship Board. We all went, Won't work. And there was a lot of modification done, and as far as I'm aware, that got resolved with regard to palliative care. And I had understood the maintaining of health and well-being was argued that that dying was part of life, and as you're approaching dying, that's also part of life. And if I failed to provide adequate pain control, or I treated people against their consent, for example, then I really wasn't honouring that in the broadest sense in terms of maintaining health and well-being, because clearly someone dying screaming in pain.
I argued the same thing back in 1990. I argued the same thing back in 1996. The thing is, there have been 3 decisions in the last 5 years from the New South Wales Administrative Decisions Tribunal, which is over the overview over guardianship, and it says that you cannot make withdrawal or withholding treatment decisions unless you are a guardian. So the general powers for persons responsible to consent to treatment do not attach to withholding and withdrawing
It's the
treatment.
withholding and withdrawing part that is difficult. Okay.
And it's very hard to separate that out from, it's very artificial to separate that out from other aspects of it.
It often is. It is in practice. I have to say, when we have taken, there are occasions when cases need to go to the guardianship board because there isn't a person responsible, blah, 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 and we go down the whole list, and that's what happens. And usually they've agreed. Yeah. I haven't ever had the guardianship board say...
And the same thing with all the Supreme Court matters, that when the Supreme Court deals with this, they deal with it really quickly and it's done professionally. But the point is, you shouldn't have to go to the guardianship tribunal every time you want to do a treatment withdrawal decision. It should be silly. It would be absolutely silly if that was the case. But the current state of the law is, if you don't have a guardian, that's really the only way that you should be doing it. And that's ridiculous.
Okay. So what got over... How did the AAT or whatever it was, Administrative Appeals Tribunal, how did they come to be overturning what I see as a general practice within the guardianship board?
No offence, but they have legal authority and you don't.
Yes, I understand that. No, but what I'm saying is, normally if we put an issue about withholding treatment...
Because the laws, the laws are set out in Part 5 of the Guardianship Act, which is the operative part. It just talks about consent. It doesn't say anything about treatment with refusal or withholding.
Yep.
And the tribunal, which is the only body which has looked carefully at this, has said that doesn't include withholding and withdrawing treatment.
Okay, so that's not consistent though with the decisions we get back. Does that matter?
No.
I'm just trying to work out how the relationship
again, you talked about how you could talk about things for hours. We could do the same thing here.
Yep.
Here's the point. Persons responsible include, starting with your family members, but they work up to officially appointed people. You can officially appoint a guardian. You could do that through the Guardianship Tribunal or Supreme Court. If you can officially appoint a guardian, they can be given powers to make end-of-life decisions. That either has to be done through enduring guardianship or a formal appointment.
Yep.
They're the only people that can make decisions to consent to palliative care and the refusal and withholding of treatment. Yep. The other people, general family members, they don't have those powers. So that's where, if you just went to a person responsible who's not a guardian, under the legislation, under the current reading, they don't have the power to do that. And it's easy to fix that by changing some of the definitions. And you could do that by adding 2 or 3 words here and there.
Or getting everybody to appoint an enduring guardian for themselves.
Yeah, but that's not going to happen. That's not really...
I'm
just trying to clarify in my own head how it is.
Or going to the tribunal every time someone gets sick.
My interest is advanced care plans or directives. We've been told we should plan for the future, but no one wants to talk about death. What the hell are they doing when they write their will? People do think about death, and I think maybe the law is where we should get a few more advanced care directives. Maybe legislation to do something this year, sometime never, but we could have more advanced care directives now.
The law says you can do it now.
Well, if the law did something towards it.
Trevor, do you want to finish?
I think we're in uproarious agreement. Advanced care directives exist as an option now. The question is how you get more people to consider them and use them frequently to take as their circumstances change. If you pass legislation, doesn't mean that the legislation requires you to use a form. After all, we've had wills for hundreds of years, and we've had legislation that backs up wills, and there is no form in which to do a will. In fact, our legislation is constantly unpacking what constitutes a will to make it more and more flexible. But be that as it may, whether I'm right whether Cameron's right, the answer is everyone has a right to direct what happens to themselves. A doctor cannot, non-consensually, except in certain circumstances, do things to you. That's the concept, or one of the concepts that underpins it. If you don't want treatment, you're entitled to say, I do not want treatment. Now, they might rush off to the Supreme Court to determine whether it's appropriate, but nevertheless, you're entitled to do that. But, you know, again, one of the problems is, and I sort of go back to my father, I've got one, and I've got one that's more extensive than you could possibly imagine. But you know, in my father's circumstance, the problem was he was confronted with an upcoming operation. He wanted to deal with the consequences of a possible operation. That is, seal me up, let me go home, let me take a pill and I'll go away. That's really what Dad wanted. But he didn't conceive that he would have a massive stroke whilst waiting to have it. So that nothing that was contained in that advanced care directive dealt with that consequence. And that's the problem. It wasn't a mistake, you know, and he was a doctor, you know, he wasn't a fool, but that was the problem that existed. So an advanced care directive, if you go and do a really complex one and you get the advice, yes, you can do a good one. But advanced care directives in and of themselves will not solve every circumstance. I've got to get in the car and drive back into the middle of Sydney tonight, as many of you will be driving around, and you won't have an advanced care directive, and it won't deal with all the circumstances of what happens when you run into a car on the way. You know, we're just not all going to cover every consequence in life, so that there does have to be other mechanisms that either allow us to have a choice, or, rightly, if we've got an enduring guardian, somebody else to make the decision for us. That's easy.
All right. We're terribly grateful to all of the speakers tonight.